The loudest sound that morning wasn't the handcuffs locking around my wrists. It was the silence that followed. I never imagined that a routine walk into the courthouse where I had spent nearly 2 decades serving justice would begin with those words echoing through my mind. My name is Aaron Bowen, and for the past 18 years I have served as a judge on the state superior court. Most people expect judges to arrive through private entrances, surrounded by security or assistants carrying stacks of files. I have never liked that. My father spent 35 years driving city buses, and he taught me that titles may earn respect, but character earns trust. Ever since I took the bench, I had made a habit of parking in the public garage 3 blocks away whenever my schedule allowed. It reminded me that the courthouse belonged to everyone, not just those wearing expensive suits or holding official positions. That Tuesday morning felt no different. The late autumn air carried just enough chill to justify my navy overcoat, and the sidewalks buzzed with attorneys reviewing notes, reporters setting up cameras for scheduled hearings, families nervously preparing to support loved ones inside, and courthouse employees balancing coffee cups while rushing toward the entrance before the first docket began. I enjoyed those quiet walks because they gave me a chance to observe the people our legal system was built to serve. Some recognized me and offered polite smiles. Others passed without a second glance, which suited me just fine. My worn black leather briefcase held nothing more dramatic than case files and handwritten notes for the morning calendar. The biggest decision on my mind was whether I would have enough time between hearings to grab lunch from the sandwich shop across the street. Then I noticed the patrol cruiser parked near the courthouse steps. Seeing police officers outside the building was perfectly normal. Security had been increased after several high-profile trials, and local officers regularly assisted with traffic and crowd control. One officer, however, stood apart from the others. He was tall, broad-shouldered, and carried himself with the unmistakable confidence of someone who believed every decision he made was the correct one. His name tag read Carlos Hewitt. I thought I had seen him once or twice during high-traffic court days, but he had never been assigned regularly enough to know my name or position. As I approached the front plaza, I noticed his eyes following me instead of scanning the crowd. At first I thought nothing of it. Years on the bench had taught me not to assume intent from a single glance. I continued toward the courthouse doors at an easy pace, passing 2 assistant district attorneys discussing a plea agreement and a law student nervously rehearsing opening statements under her breath. I had almost reached the first granite step when I heard a sharp voice cut through the morning noise. "You there? Stop." Several pedestrians instinctively looked around, unsure who had been addressed. I slowed, turned, and realized Officer Hewitt was staring directly at me. His expression wasn't one of curiosity. It was certainty. He closed the distance between us with measured steps, one hand resting near his duty belt while the other motioned for me to remain exactly where I was. Conversations nearby began fading as people sensed something unusual unfolding. I offered a calm nod, assuming there had been some misunderstanding that could be resolved in seconds. Instead, Officer Hewitt planted himself directly in front of me, looked me up and down, and said in a firm voice that carried across the courthouse entrance, "Sir, put your hands where I can see them." I slowly raised both hands to shoulder height without making any sudden movement. Years in the courtroom had taught me that calm often revealed more than anger ever could. Officer Hewitt stepped closer, studying my face as though he had already reached a conclusion before asking a single question. "Do you have identification?" he asked. "I do," I answered evenly. "It is in the inside pocket of my coat. May I reach for it?" Instead of responding immediately, he shook his head. "Not yet." His tone suggested that my cooperation did not matter because he believed the situation was already under control. Around us, the normal rhythm of the courthouse entrance began to slow. A pair of attorneys stopped halfway up the steps. A family waiting for a custody hearing looked over with quiet concern. A television photographer who had been preparing for an unrelated news story subtly turned his camera toward the growing scene. I could feel dozens of eyes settling on us, yet I kept my voice measured. "Officer, could you please explain why I have been stopped?" He answered without hesitation. "You match the description of someone we are looking for." "May I ask what description?" I replied. "You do not need to ask the questions," he said. "I do." His confidence never wavered, but something about the exchange immediately struck me as incomplete. Law enforcement officers often have legitimate reasons to conduct investigative stops, and I had reviewed enough cases over the years to understand the legal standards involved. Even so, I also knew that clear communication frequently prevented unnecessary escalation. I remained still and said, "I am willing to cooperate fully." For a brief moment, I thought the situation might end there. Instead, Officer Hewitt took one more step forward and instructed me to turn around. That single request caused several people nearby to exchange uneasy glances. A young assistant public defender quietly whispered something to her colleague while continuing to watch. An older attorney reached into his pocket, apparently considering whether to make a telephone call. The atmosphere shifted from curiosity to discomfort, and I realized this encounter was no longer passing unnoticed. Before I could speak again, Officer Hewitt directed me toward the front of his patrol vehicle parked along the curb. "Place your hands behind your back," he said. I looked directly at him and replied in the same calm tone I had maintained from the beginning. "Officer, I have not resisted you. I have answered respectfully. I believe there has been a misunderstanding." "You can explain everything later," he answered. The metal handcuffs closed around my wrists with a distinct click that echoed across the stone entrance plaza. Conversation stopped almost instantly. Nobody shouted. Nobody rushed forward. The silence itself became the loudest reaction. I heard someone quietly say, "That cannot be right," but I could not tell who had spoken. Several people reached for their phones, while others simply stared, unable to reconcile what they were seeing. I lowered my eyes for only a moment, not from shame, but because I understood how quickly appearances shape public opinion. To every stranger watching, I was no longer a man walking into work. I was simply a black man in handcuffs outside a courthouse. Then, from the top of the courthouse steps, I noticed a familiar face emerging through the revolving doors. The young judicial clerk froze the instant she saw me, and the expression on her face told me she recognized something Officer Hewitt had not. The young judicial clerk stood motionless for only a second before hurrying down the courthouse steps, her expression shifting from confusion to alarm. I recognized her immediately. Her name was Donna Hingis, and she had worked in my chambers for almost 3 years. She was bright, composed under pressure, and rarely let emotion show in public. Yet the look on her face now told me she was struggling to process what she was seeing. "Officer," she called respectfully as she approached. "May I speak with you for a moment?" Officer Hewitt extended one arm, signaling for her to stop several feet away. "Ma'am, this is an active police investigation. Please stay back." Donna looked from him to me, then back again. "I think there has been a misunderstanding," she said carefully. "This gentleman." Before she could finish, Officer Hewitt interrupted her. I said stay back. His voice remained controlled, but it carried enough authority that she hesitated. I met her eyes and gave the slightest shake of my head. She understood immediately. I did not want anyone creating unnecessary conflict on my behalf. The law deserved calm even when the situation felt anything but calm. Donna pressed her lips together, stepped back without arguing, and reached into her coat pocket. She did not dial immediately. Instead, she seemed to think through her next move with remarkable care. Watching her remain composed gave me confidence that someone would make the appropriate notification without escalating the scene. Nearby, more courthouse employees began arriving for work. Several recognized me almost instantly. Some stopped walking altogether. Others whispered quietly among themselves. I could see questions forming on their faces, but nobody rushed forward. They understood that interfering with a police stop could create more complications than solutions. The unusual silence spreading across the entrance carried far more weight than raised voices ever could. Then an older attorney named Gary Hayden emerged from the security checkpoint. We had known each other professionally for nearly 15 years. He paused halfway down the steps, adjusted his glasses, and stared in disbelief. "Aaron," he said before catching himself. He took 2 cautious steps toward us. "Officer, I believe you may wish to verify." "Sir," Officer Hewitt cut in firmly. "If you interfere with an active investigation, you may be asked to step back from the area." Gary stopped immediately. He slowly raised both hands to show he had no intention of interfering. "I am only suggesting that you verify the identity of the individual before proceeding any further," he replied calmly. "His identity will be verified when I decide it is time," Officer Hewitt answered. Gary looked directly at me. I simply nodded once, encouraging him to remain patient. I had spent years reminding attorneys that the courtroom was built upon procedure rather than emotion. Now it was my turn to live by that principle. Even if the process felt deeply flawed in this moment, I refused to abandon the standards I expected from everyone else. A few yards away, Donna finally placed a telephone call. She spoke quietly enough that I could not hear every word, but I caught one sentence carried by the morning breeze. "Please come outside immediately." She ended the call within seconds and looked back toward the courthouse entrance instead of returning to us. That small detail told me she had contacted exactly the person she intended to reach. Donna had reached Graham Avery while his sedan was already entering the secured court complex. Less than a minute later, the vehicle turned into the courthouse driveway, displaying the official parking credentials reserved for senior court administration. As the vehicle rolled to a smooth stop near the entrance, every attorney, clerk, and deputy marshal nearby instinctively shifted their attention toward the rear passenger door just before it slowly opened. The rear passenger door opened, and Graham Avery, the executive court administrator, stepped onto the sidewalk with the composed confidence of someone accustomed to solving problems before they became crises. He was in his early 60s, impeccably dressed, and carried no visible sense of urgency, yet I knew him well enough to recognize the subtle tightening of his expression the instant his eyes met mine. He did not rush toward me. He first surveyed the entire scene, taking in the patrol vehicle, the gathering crowd, Officer Hewitt's posture, and the handcuffs around my wrists. Only then did he begin walking forward at an even pace. "Good morning, officer," he said politely. "May I ask what is taking place here?" Officer Hewitt answered without hesitation. "This individual matches the description of a person connected to an ongoing investigation. He is being detained until I complete my verification." Mr. Avery nodded as though considering the explanation carefully. "Has his identity been confirmed?" "Not yet," Officer Hewitt replied. "That will happen when I determine the appropriate time." Mr. Avery remained remarkably calm. "Would you mind telling me whether the individual has been cooperative?" "He has followed instructions," Officer Hewitt admitted. "But that does not change the fact that I have reasonable suspicion." I watched the conversation unfold without saying a word. My instinct was still to let procedure take its course. Years on the bench had taught me that the facts often revealed themselves most clearly when people were allowed to explain their own decisions without interruption. Mr. Avery glanced briefly toward me before returning his attention to Officer Hewitt. "Thank you for explaining," he said. "If you will excuse me for just a moment." Instead of arguing or identifying me, he stepped several feet away and removed his cellular telephone. He spoke quietly enough that nobody nearby could hear the conversation, but I noticed his tone remained steady throughout the call. He was not asking for permission. He was notifying the appropriate officials. When he returned less than a minute later, nothing about his demeanor had changed. That calmness seemed to unsettle several people watching from the courthouse steps. Donna folded her hands together, trying to hide her anxiety. Gary Hayden checked his watch, then looked toward the driveway as though expecting additional arrivals. Even Officer Hewitt briefly glanced around before returning his attention to me. It was the first moment I sensed the certainty in his posture begin to soften, although his voice remained firm. "Sir," he said to me, "if you have identification, you will have an opportunity to present it shortly." "I have been prepared to do so since you first asked," I answered evenly. He did not respond. The silence stretched across the plaza again. Reporters who had originally gathered for unrelated court proceedings now quietly repositioned themselves for a better view, sensing that something unusual was unfolding. Nobody shouted questions. Nobody crossed the police perimeter. They simply watched. Then the distant sound of approaching engines echoed through the courthouse entrance. Heads turned almost in unison toward the driveway. Within moments, 3 government vehicles entered the secured access lane, one behind another, with official courthouse credentials clearly displayed on their windshields. Deputy marshals standing near the entrance immediately straightened their posture. Court employees exchanged uncertain glances. Even Officer Hewitt looked toward the arriving vehicles before slowly turning back to me, unaware that the people stepping out were about to recognize me long before he ever did. The 3 vehicles came to a smooth stop one after another, and several senior court officials stepped onto the courthouse plaza with quiet purpose instead of visible alarm. Leading the group was Chief Judge Jane Lloyd, followed by Chief Marshal Joshua Lester and Deputy Court Administrator Layla Perez. Graham Avery stepped aside to brief them quietly, remaining nearby as the senior officials assumed responsibility for the court's response. None of them hurried. None of them raised their voices. Yet the atmosphere changed the instant they appeared. Attorneys standing near the entrance instinctively stepped aside to clear a path. Deputy marshals straightened their jackets. Even the television reporters lowered their conversations, sensing that something far more significant than an ordinary detention was unfolding. Chief Judge Lloyd walked directly toward me without hesitation. Her eyes briefly rested on the handcuffs before meeting mine. "Good morning, Judge Bowen," she said in the same respectful tone she had used every working day for years. "Are you all right?" Her question echoed across the suddenly silent plaza. I noticed several people in the crowd exchange stunned looks. One young law student quietly whispered, "Did she just call him Judge?" Another attorney removed his glasses as though he had heard incorrectly. Officer Hewitt remained perfectly still for a moment. His expression changed almost imperceptibly as he looked from Chief Judge Lloyd to me, and then back again. It was clear that he had not expected anyone to address me that way. Chief Marshal Lester stepped closer, speaking calmly to Officer Hewitt. "Officer, I am Chief Marshal Joshua Lester for this courthouse. May I ask whether there is a particular reason Judge Bowen has been placed in restraints?" Officer Hewitt cleared his throat before answering. He matched the description of an individual connected to an investigation, and I detained him according to procedure. Nobody challenged his statement immediately. Chief Judge Lloyd simply asked, "At what point was his identity verified?" Officer Hewitt hesitated for the first time since stopping me. I had not yet completed that process. The brief pause was enough for several experienced attorneys watching nearby to exchange knowing glances. I had spent years reminding lawyers that the smallest hesitation during testimony often mattered more than the longest explanation. Donna quietly lowered her eyes, while Gary Hayden folded his arms without saying a word. The plaza remained silent except for the distant traffic beyond the courthouse square. Chief Judge Lloyd turned toward Chief Marshal Lester. "Please have the restraints removed immediately, but document their condition and the exact time before doing so." I nodded in agreement. I also asked that every recording, dispatch notice, witness account, and instruction leading to this moment be preserved. Removing the restraints should not erase the decisions that placed them there. Chief Marshal Lester acknowledged the request and instructed a deputy marshal to photograph the restraints in place, record the time, and then remove them according to standard procedure. Nobody spoke for several long seconds. I could see that Chief Judge Lloyd understood exactly what I meant. This was no longer simply about one mistaken detention. It was about documenting every decision exactly as it had occurred, without emotion replacing facts. She slowly nodded. "Very well," she said. "The record should reflect the complete sequence of events." Then she turned toward Officer Hewitt with the same composed professionalism that had earned respect throughout the state's judicial system, and asked one simple question that instantly shifted the weight of the entire morning. "Officer, would you please explain, step by step, exactly what specific facts led you to stop Judge Bowen before verifying who he was?" Officer Hewitt drew a slow breath before answering. The confidence that had marked every decision he made since stopping me was no longer as steady as it had been only minutes earlier. Still, he stood upright and addressed Chief Judge Lloyd with professional formality. "I received information regarding a possible suspect seen near the courthouse this morning," he said. "Based on what I observed, I believe this individual matched that description." Chief Judge Lloyd nodded once. "Please continue." "I initiated a lawful stop," he replied. "The individual complied with my instructions, but I chose to secure him before completing identification." Nobody interrupted him. That silence was intentional. Experienced judges understand that allowing someone to fully explain a decision often reveals more than aggressive questioning ever could. I remained exactly where I was, listening as carefully as everyone else. Then Chief Marshal Lester asked a simple question. "Could you describe the information you received?" Officer Hewitt paused briefly before answering. "Male, African American, approximately 6 feet tall, dark overcoat, carrying a black briefcase." Several attorneys exchanged subtle glances. I noticed Gary Hayden slowly lower his head as though he already understood where the conversation was heading. The description Officer Hewitt had just provided could have applied to countless professionals arriving for work throughout the courthouse district on any weekday morning. Chief Judge Lloyd remained calm. Did the information include facial characteristics? No. Age? No. Any distinguishing features? No. Another quiet pause settled over the plaza. Nobody rushed to fill it. The absence of noise somehow carried greater weight than any accusation could have. I finally spoke for the first time since my identity had been acknowledged. Officer Hewitt, when I asked whether I could present identification, do you recall my exact words? He looked toward me. You said your identification was inside your coat. Did I refuse to provide it? I asked. No. Did I make any movement suggesting I intended to flee? No. Did I threaten you in any way? No. He answered each question honestly, and I appreciated that. Truth mattered, even when it arrived one sentence at a time. The crowd remained completely silent. Donna stood near the courthouse steps with her notebook pressed against her chest. Reporters continued recording without asking questions. They understood that the facts unfolding naturally were more powerful than any commentary. Chief Judge Lloyd turned slightly toward Officer Hewitt again. Was there any reason you believed immediate restraints were necessary before confirming the identity of a cooperative individual standing in front of the courthouse entrance during business hours? Officer Hewitt did not answer immediately. His eyes shifted briefly toward the patrol vehicle before returning to the chief judge. I believed it was the safest course of action. She accepted the answer without argument. Very well, she said. That explanation will be included with the record. I could tell she had chosen her words carefully. She was not reaching conclusions. She was preserving facts. That distinction was one of the foundations of a fair judicial process. Then Chief Marshal Lester quietly spoke into his portable radio, requesting that all available recordings related to the incident be preserved according to standard evidence retention procedures, including courthouse security footage and Officer Hewitt's body camera recording. I noticed Officer Hewitt's expression change again. It was subtle, but unmistakable. For the first time that morning, he seemed to realize that this moment would not be remembered through conflicting opinions or incomplete recollections. Every word, every instruction, and every decision would soon be reviewed exactly as it had happened. Just then, one of the deputy marshals approached Chief Marshal Lester, leaned close enough to speak privately, and handed him a printed incident bulletin. After reading only the first few lines, the chief marshal slowly lifted his eyes toward Officer Hewitt and asked, Officer, is this the suspect description you were actually given before the stop? Chief Marshal Lester held the incident bulletin in his hands for several quiet seconds before extending it toward Officer Hewitt. Please confirm whether this is the dispatch you received this morning, he said. Officer Hewitt accepted the paper and began reading. From where I stood, I could not see the text itself, but I did not need to. I watched his expression instead. The certainty that had defined every decision he made since stopping me gradually gave way to hesitation. He read the first page once, then lowered it slightly before reading the opening lines again. Chief Judge Lloyd did not interrupt him. She simply waited. Patience, I had learned over many years on the bench, often encouraged honesty more effectively than pressure ever could. Finally, Officer Hewitt spoke. This appears to be the original dispatch. Chief Marshal Lester nodded. Would you mind reading the suspect? Description allowed for everyone present. The request was calm, direct, and impossible to misunderstand. A noticeable silence settled across the courthouse plaza. Even the reporters stopped adjusting their equipment. Officer Hewitt looked at the page again before reading slowly. White male, approximately 30 years old. Brown jacket, blue baseball cap, carrying a gray backpack. Last seen leaving a nearby parking structure. No one reacted immediately. Nobody needed to. The difference between those words and the description Officer Hewitt had given only moments earlier spoke for itself. I remained still, listening carefully. Chief Judge Lloyd asked, Does that description resemble Judge Bowen in any meaningful respect? Officer Hewitt lowered the paper without answering. His silence lasted several long seconds. Officer, she repeated gently. No, he admitted quietly. Gary Hayden exhaled almost imperceptibly. Donna closed her eyes for a brief moment before looking back toward me. Around us, people exchanged restrained glances, but to their credit, nobody applauded, laughed, or made sarcastic remarks. The courthouse represented the rule of law, and everyone present seemed to understand that dignity mattered, even in difficult moments. Chief Marshal Lester then addressed one of the deputy marshals. Please make certain the original dispatch bulletin is preserved with today's documentation. Yes, sir, the deputy replied before carefully placing the bulletin into an evidence folder. The decision was routine, but it underscored that the documentation would rely upon original records rather than memory. I spoke again, keeping my voice steady. Chief Judge Lloyd, I would like to make one request. She turned toward me immediately. Go ahead, Judge Bowen. I respectfully ask that I not participate in reviewing any complaint or investigation arising from this incident. Several attorneys looked surprised. One reporter quietly whispered something to a colleague while continuing to record. Chief Judge Lloyd studied me for a moment. May I ask your reasoning? Because I am personally involved, I answered. A judge should never evaluate a matter in which his own experience could influence his judgment. Public confidence depends not only upon fairness, but upon the appearance of fairness. I saw several young law clerks listening carefully. Perhaps this unexpected lesson would remain with them longer than any lecture inside a courtroom. Chief Judge Lloyd smiled almost imperceptibly. Your request is appropriate and will be honored. She turned to Chief Marshal Lester. Please arrange for any review to be handled by an independent judicial district with no professional connection to Judge Bowen. It will be done, he replied. Officer Hewitt remained silent throughout the exchange. For the first time that morning, he was no longer the person directing events. Procedure had taken over, and procedure treated every participant the same. Then Chief Marshal Lester received another message through his radio. He listened for several seconds before looking toward Chief Judge Lloyd. The body camera recording has already been secured, he said. He paused briefly before adding one final sentence that caused every person standing outside the courthouse to focus their attention on him once again. The recording begins nearly 2 minutes before Officer Hewitt first approached Judge Bowen. The preliminary system log also confirmed that no amended suspect description had been transmitted to Carlos's radio, mobile terminal, or department-issued phone before the stop. Chief Marshal Lester lowered the radio slowly, allowing the significance of his words to settle over the courthouse plaza. The body camera recording had not begun at the moment I was stopped. It had begun well before that. The preserved footage showed Officer Hewitt watching several white men carrying briefcases and backpacks cross the same plaza without intervention. Only when I approached did he leave his position, follow me with his eyes, and begin moving toward the courthouse steps. That meant the review would capture not only our conversation, but also everything leading up to it. Nobody spoke for several seconds. Chief Judge Lloyd finally broke the silence. Then the review will include the complete context. Yes, Your Honor, Chief Marshal Lester replied. The recording has been secured under standard evidence preservation procedures. I nodded quietly. Complete context had always mattered to me more than isolated moments. Inside a courtroom, I had seen countless situations where 10 additional seconds of video completely changed the understanding of an event. If the same standard applied to every citizen, it should certainly apply here. Chief Judge Lloyd turned toward Officer Hewitt once more. You have been cooperative since we arrived, and that cooperation will be reflected in the record. From this point forward, the independent review will determine whether every decision complied with departmental policy and constitutional standards. Officer Hewitt lowered his eyes briefly before answering. Understood. His voice no longer carried the certainty that had marked the beginning of the encounter. It sounded measured, almost reflective. Chief Marshal Lester confirmed that the restraint photographs, removal time, and body camera preservation request had all been entered into the incident record. Before the officials moved on to the next step, I looked toward Chief Judge Lloyd. May I make one additional request? She inclined her head. Of course. When the review begins, I would prefer that nobody receive special treatment because I happen to serve on the bench. If the same procedures would apply to any member of the public, they should apply here as well. Chief Judge Lloyd smiled slightly. That is exactly why the matter is leaving this district. With the restraints already removed and documented, I flexed my wrists only long enough to restore circulation before placing my hands calmly at my sides. There was no applause from the crowd. No dramatic celebration. Instead, many people simply returned to breathing normally, as though an invisible weight had finally lifted. Yet I knew the story was not over. It should not end with the restraints coming off. It should end with lessons that could improve the system itself. As reporters quietly packed away some of their equipment, Chief Judge Lloyd addressed the assembled court officials. I would also like a comprehensive review of pedestrian stop procedures surrounding this courthouse complex. This incident should prompt us to examine whether our existing coordination between courthouse personnel and local law enforcement can be strengthened. Several administrators immediately wrote notes. Nobody treated the suggestion as symbolic. It became a concrete administrative action before everyone watching. Officer Hewitt looked toward me for the first time since my identity had been confirmed. "Judge Bowen," he said carefully, "I understand that my actions today will be reviewed." I met his eyes. That is how accountability works for all of us. He nodded once, but said nothing more. The exchange lasted only a few seconds, yet it seemed to settle something neither of us needed to explain. As the officials prepared to return inside for the morning docket, Chief Judge Lloyd reminded me that another judge would cover my first hearing, so I would not be delayed by the required documentation. I thanked her and watched everyone begin moving again. The courthouse slowly returned to its ordinary rhythm, but I had the unmistakable feeling that this morning would leave a lasting impression on everyone who had witnessed it. The independent review concluded that Officer Hewitt had lacked an objective basis to stop me under the original dispatch description, had delayed identity verification without justification, and had used restraints against a cooperative man who did not resemble the reported suspect. It also found that racial bias had influenced Officer Hewitt's decision to reinterpret a description of a young white man as applying to an older black man. The department imposed formal corrective discipline, removed him from patrol duties, and required supervised retraining before he could hold any instructional responsibility. Several months later, after the independent review had been completed and the headlines had faded, I unexpectedly found myself walking into a state law enforcement training academy where one familiar face was already waiting near the front of the classroom. The training academy classroom looked nothing like the courthouse where our paths had crossed months earlier. Instead of marble floors and quiet hallways, there were rows of desks, legal reference books, and dozens of newly hired officers preparing for the final week of their academy instruction. I had been invited to speak about constitutional decision-making and public confidence in the justice system. As I walked toward the front of the room, I immediately recognized Officer Carlos Hewitt standing near the instructor's podium. He remained removed from patrol duties under supervisory review after completing the corrective measures required by the independent investigation. After completing mandatory retraining and remaining off patrol under supervisory review, he had been invited to participate in one professional development session, not as an instructor, but as the subject of a documented case study on how unchecked assumptions can distort police decision-making. When he saw me, he walked over without hesitation. "Judge Bowen," he said quietly, "thank you for coming." There was no attempt to explain away what had happened, no effort to minimize it. He simply stood there for a moment before continuing. I spent years believing that experience meant I could make quick judgments about people. That morning showed me how dangerous that assumption can become when it replaces careful observation. I appreciated that his words were directed neither toward defending himself nor seeking sympathy. They reflected genuine reflection. I answered honestly. Every profession that carries authority also carries responsibility. Judges learn that every day. Officers learn it every day as well. He nodded. The independent review was difficult to read, but it was fair. It pointed out mistakes I could not see while I was making them. Before the session began, he surprised me again. The academy instructor asked whether Carlos was willing to briefly discuss the findings of his case review before my presentation. Carlos agreed without attempting to minimize them, and I welcomed the opportunity for the recruits to hear his account directly. Standing before the recruits, he described the importance of verifying facts before reaching conclusions, the value of listening when someone cooperates, and the reason accurate documentation protects both the public and law enforcement officers alike. He never mentioned pride. He never blamed anyone else. He simply explained how quickly confidence, without careful judgment, could lead to unnecessary mistakes. When he finished, the classroom remained silent for several thoughtful moments before the instructor thanked him for his honesty. I then delivered my presentation, not about what had happened to me personally, but about the principles that allow justice to earn trust one decision at a time. At the conclusion of the program, Carlos extended his hand. I shook it warmly. The past could not be rewritten, but the future could still be influenced by what people chose to learn from it. As I walked toward the parking lot that afternoon, I realized the memory I would carry from that experience was no longer the sound of handcuffs outside a courthouse. It was the sound of an officer standing before the next generation with enough humility to admit that fairness begins by resisting the temptation to assume we already know the whole story. Perhaps that is one reason trust takes so much longer to build than to lose. It grows quietly through ordinary choices, careful listening, and the willingness to pause before reaching conclusions. This story reminds us that fairness is rarely defined by a single dramatic moment. More often, it is shaped by the habits people practice every day when nobody is watching. There are times when accountability is not only about correcting a mistake, but also about creating an opportunity for others to avoid repeating it. Sometimes the most meaningful outcome is not found in punishment alone, but in a sincere commitment to learn, improve, and strengthen the systems that serve every member of the community. If this story stayed with you, I would love to hear what part affected you the most. If you found yourself standing in either Aaron Bowen's or Carlos Hewitt's place, what choices would you have made, and what would you hope others learned from your experience?